Nice. Well, welcome everybody. My name is Marty Mascari. I am with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth, Texas area. We are blessed once again to have our partners at Heyman Hogue here to talk to us and give us their wisdom about what happens when the first spouse dies. And thank you for your patience. For those of you that registered in February and are now joining us, we sure appreciate your patience. But we did get it. We did get it on the schedule, and here we are. So I'm going to first start and turn it over to Sheila and let Sheila talk about CEUs for those of you that are joining us looking for CEUs.
Well, good morning, everyone. I am Sheila Williamson with Heyman Hogue, and let me explain. We're so happy to do educational events for you, and let me explain how this works. If you are a nurse, a social worker, an LPC, or an assisted living manager, then this is for you. Well, obviously it's for anyone, but I mean, your credit, you get continuing education credit for this. So in order to do that, you watch the webinar, and then Marty will send you a follow-up. If you're registered, he will send you a follow-up, and it will have the forms on there that you need to return to me. One is a sign-up sheet, which you're used to doing, and one is an eval form. Evaluating Susan and Austin and the material, etc. So please send those back to me. And keep in mind that we educate, we do not sell. We educate, but we do this for a living. So you have been fully versed in that this is what we do, and that's why they're experts in their field and can educate you. So this way you can help your clients, hopefully, with their questions and with some other wisdom that you can impart to them. Okay, that's it.
Great. In addition to the paperwork that I'm going to send you from Sheila, we also there's a Google survey that we ask you to fill out if you would. It should pop up as you close out of Zoom today. If not, you'll also receive the link to that survey in the follow-up email. That survey is really to help us report back on the goals and objectives we set forth when we applied for the funding to put on these webinars. So if you do that, we'd certainly appreciate it. Mike, I'm going to ask you your question real quick. I saw that you're signed in. You will not be able to see yourself. We are in webinar format, not meeting format. In webinar format, the only people that will be able to open up their mics or have their cameras working are the panelists. So you won't be able to be opening that up. So Sheila, I'm going to let you introduce Susan and Austin, if you would, and roll.
Well, you know, we're so fortunate to have so many attorneys that are knowledgeable in so many fields. But in this particular subject, which we have had, thank you very much for those of you that have answered the bottom question on the eval said, do you have suggestions for further programs? And you did. And this is why we're offering this one. We have our probate, the heads of our probate team on today, because when a person passes, then probate may be required. And they're going to talk about that whole process. Anyway, the head of our probate team is Susan Barnett, who is one of the partners at Heyman Hogue. Susan has more than 20 years experience in the law. And so I doubt you can ask any question that she's not going to be able to answer. But then we have Austin Butts, who you've heard many times on here before, educating, and Austin has 6 years of experience himself. So between the two of them, they have so much experience in this genre that I believe they'll be able to answer any question. I did forget to mention, please, you can type your questions in the chat, and then at the end, because it disrupts the continuity for everyone, we will answer the questions. And I promise you, I monitor those, and we will answer every question that we can get to. Okay, without further ado, Susan and Austin.
Hey, everybody, I'm Susan Barnett. As Sheila mentioned, I am one of the partners here at Heyman Hogue. I ask you please not to take her statement as a challenge to stump the attorneys, because, I probably don't have all the answers, but I've been doing this a while. And so if we don't have answers and there's something specific, we'll get information from you and we'll get back to you on anything like that. But we want to talk about what are the kinds of things that happen when you've got a couple and the first spouse dies. And I handle it within our firm. I am head of the estate administration team, as Sheila mentioned, which involves probate. And Austin does a whole lot of our probate cases. And it also involves trust administration. So people with living trusts, when they die, there is work to be done. We'll talk a little bit more in detail about that later. And we do what is called trust administration. And so Austin and I deal with a lot of people who have lost someone they love. And sometimes the most difficult situation is when the first spouse dies, because that's a life partner that nobody wants to lose. And depending on the dynamics of the family, it could leave that surviving spouse really feeling very lost. And so we spend a lot of time trying to help people walk through this piece of life. And it is a journey, and we feel very privileged when we are allowed to walk through that with them. Austin, you want to introduce yourself before I get going?
Sure. Yeah, my name is Austin Butts. I'm an attorney here at Heyman Hogue. I've actually got 8 years of experience now. Like Susan said, I'm part of the estate administration team, and I focus more on the probate side. And I also do a lot of the estate planning at our firm to avoid the need for probate. So today, I'll let you know what to expect, what we're going to be discussing. Be prepared to learn. Susan is going to be talking about the steps to take immediately following the death of the first spouse. There are a lot of practical things that need to be done, and it can be an overwhelming time for a lot of people. And so hopefully this gives good information to more or less have a checklist of this is what needs to be done at this point. And then I'm going to be talking about how assets are transferred when a spouse passes away. That could be probate, that could be by contract, by trust. There's different ways it can happen, and then go through all the different options. And then at the end, I'll make a recommendation for what we feel are the best options for passing assets.
So when one of the first things that needs to happen when that first spouse passes away is that you need to notify the professionals that are in your life. And I'm going to talk to you guys as if you are that surviving spouse. I know that you've got clients and different people you work with in different capacities that you would be passing some of this information on to. And so I'm just going to talk to you as if you are that surviving spouse. But yeah, first thing, call the estate planning attorney. Whoever put documents together for you and your spouse, you want to call them and let them know that your spouse has passed, and don't make a lot of other moves without having that conversation. If there are no estate planning documents, which happens very commonly, then you need to reach out to an attorney that handles probate and make sure that you've got help along the way with that. It's a process that you are required to have an attorney for, and you want to make sure that you do everything right from the beginning. You also want to contact your CPA. Let them know they'll be starting to think about things that might impact your taxes and things like that. So you want to make sure that they know what's going on. They are part of an important team of people that will work to help walk through this journey. And then if there is a financial advisor that your family has, you want to let them know what's going on as well. Now, doesn't mean stop right away and call all the banks. The banks will get word automatically through the system as you go through this process. But your financial advisor needs to know what's going on so that they can be on the lookout for anything that's unusual activity, and then help walk you through the transfer of assets when it's time. Social Security needs to be notified. As a general rule, it's done by the funeral home or whoever you've got working with the remains. But they do have to be notified. And so if that's not taken care of automatically, it's a call you would want to make. But generally speaking, it is taken care of automatically. With Social Security, there's a lump sum death benefit. Last I heard, I think it is a grand total of $250. But still a little bit, everything counts in this circumstance, and eventually that's going to come through. And then depending on which spouse has passed, if the deceased spouse had a higher Social Security payment every month, then there's going to be an adjustment in the survivor's payment. And so that's another reason that you want to make sure that they know about the death. If your spouse was a veteran and was getting any kind of veteran benefits, you want to make sure that the VA knows that they've passed. This is an area all into itself. There's lots of benefits for veterans, and it's not always easy to figure out what they are. And so any veterans out there need to really be aware and let you know if there are benefits. Get out there and find out if there are benefits that would benefit you or your spouse. If the deceased spouse had a pension plan of any kind, they're going to need to know. And they've been making payments. Things are going to change in some way, likely. And so you need to find out who the designated beneficiaries are of the pension plan, if it's going to continue or not. You also need to make sure that they're aware of the change in the payments and that they help you walk through that. And there might be some elections and deadlines that need to happen, and you want to know about those in plenty of time to make those elections. And then the description of the amount of benefits. Sometimes there's a death benefit. TRS is one that typically will have a $10,000 death benefit, and then a pension of some sort that may or may not continue. So you want to know what those benefits are. And then again, procedures and time limits for getting those benefits. You want to make sure that you notify any insurance companies. You want to stop premiums that are being paid on the life or the health or the long-term care of the deceased spouse. And so you want to stop the premiums. And then if there is something, like life insurance where there's a beneficiary designation, then you want to make sure that they get that process started to get that beneficiary paid. And generally speaking, it's usually the surviving spouse. And those are the kind of things that we like to know about so that we can help navigate that. With health insurance, you might be due a refund, unlikely. With long-term care insurance, one of the things you need to know is they pay the long-term care insurance out at the end of every month if somebody's using it. If you've got premiums, you want to make sure they stop the premiums. But if the deceased spouse was using the long-term care insurance, that gets paid at the end of the month. And that means that unless the person actually died on the first day of the month, there's going to be a final payment. And you want to make sure that they get that final payment to you prorated for that month that they died in. Now, you've got lots of documents that you need to gather. We provide a checklist for our clients to make sure that they know the kind of things to gather. And there's different reasons you might need them, but it's always helpful for us to know what you've spent when it comes to funeral costs, memorial, any of those kind of things, last medical bills that might come in. And then also any outstanding bills or debts that are in the deceased spouse's name. because those need to be handled appropriately. You're going to order death certificates through the phone, through the funeral home. And I always recommend you get plenty because they're not cheap, but they're harder to get later than they are when the funeral home orders them for you. And they'll ask you how many you want. And really what you need to think about is how many different types of assets or financial institutions would you be dealing with, and make sure you have plenty to cover that. Usually 20 is a good number. If you don't have anything but a bank account and a house, something like that, then maybe 5 or 10. But I would rather see you get more than have to go back and order them later, because it's just a little bit more difficult. Whatever estate planning documents are out there, you want to gather those. Now that's going to be things like a will, a living trust. Go ahead and gather up anything that was done. Generally speaking, there's a packet of documents when someone does have their documents in order. There's a packet of documents. Some of them are no longer good, and some of them are still active documents. And so you want to take all of that with you when you go to meet with the attorney, because they can cull out the ones that are no longer good, and they can make sure you understand what you need to keep and why. So gather up all of that you can. Sometimes it's quite the hunt. If it's been 20 years since you've done any estate planning with your spouse, then it's quite the hunt. So these are the kind of things when we talk about gathering documents that, while both are still alive, they're good things to have in an organized place where not only you, but maybe the next person in line that would be helping with things like your executor or your successor trustee knows where to find them. And so I would keep them, and it's never too early to have these things where they belong so that they're easily found. It's good to have tax returns for the previous 2 years. It helps your attorney know what kind of assets you might have. If you're pulling income from an IRA, that's going to be obvious there, and they'll know where to chase some of those things down. So it's a good source document. And then recent property tax bills will help with identifying real estate that's potentially in the estate, and at least gives you a general sense of value to start with. It's always good to provide financial account statements. There are knowing what that date of death value was of all these kinds of financial accounts can become very important depending on the value of the estate and whether an estate tax return is needed. But regardless, there's going to be, if there's a probate, there's going to be an inventory done, and the question is going to be, what were the value of the assets at the time of death? And so getting that statement that covers that date of death on these kind of accounts is really critical. And the earlier you gather it, the easier it is. Some other financial documents that you want to be aware of: life insurance policies, any annuities or bonds, stock certificates. These are things that are going to give us good information to know where to look for assets. Business entity documents. If you've got a family business of any kind, make sure that those documents are in order. Keep them all in one binder, all together, so that when the time comes that somebody needs to look over that and figure out what the next steps are, they've got everything right there in front of them. When it comes to taxes, there are several different types of taxes that we look at when someone has passed away. The first is to evaluate whether an estate tax return has to be done. Right now, the estate tax exemption amount is $12,192,000 per person. And so if you and your spouse have an estate that's worth under 24 million, then there's not going to be a need for an estate tax return on the first death, because each one of you has that exemption available. And that means that you can have that much in assets before there is any kind of an estate tax due. Now, that number changes every year. It went up drastically in, I believe it was 2020. And at the end of 2025, it is the law that caused that is set to sunset, and it's supposed to be cut in half. Right now, we don't know what's going to happen because that's in the hands of Congress. And so we don't know how that's going to actually play out. But the default right now is that 12 million is going to go between 6 and 7 million per person, which still sounds like a lot. But for some high net worth clients, that can make a huge difference in whether they have an estate tax return or not. So that is one of the first things we evaluate and get out of the way. Most of the time, it's really clear if they're going to need an estate tax return. There's also an issue that very few people are aware of until they're told by their CPA or their attorney or maybe their financial advisor. But on that first death, you get a step up in Texas, you get a step up in basis on the value of your assets. So what that means, best example I can give is, let's say you buy a share of stock for $100 and you sell it 6 months later for $200. You've just made $100 on that share of stock, and that is capital gains. And so you will have capital gains taxes on $100. If instead you buy the stock at $100 or let's say your spouse buys the stock at $100, and so it's community property because it was bought during marriage, and then the spouse dies and it's worth $200 when he or she dies, you automatically, I say automatically, it happens as long as you get the right documentation in place. You get a step up in the basis so that instead of the purchase price, you're looking at the value at the time that the first spouse dies. And this can be huge. So at dying with it at $200, if the surviving spouse then turns around and sells it for $205, they're only paying capital gains on that $5. And so you can see where this can make a big difference. Where we really see it is with the home, because oftentimes when the first spouse dies, they've lived in a home for 20, 30 years. And with real estate market the way it's been, they are really looking at a huge gain. And while a homestead, you've got a $250,000 per person exemption for a homestead for capital gains, you can easily get up over that if you can imagine selling a home that you bought 20 or 30 years ago. And so getting the right appraisals or the right evaluations done so that you know the value at the time of death is really critical for that step up in basis, so that you minimize capital gains, if not wipe them out altogether. And then, of course, that deceased spouse is going to have a final income tax return, and it can be filed as a joint tax return, but your CPA is going to do some additional, give some additional information to the IRS to let them know that that spouse has died and that this is their final income tax return.
All right, now we're going to talk about how assets pass upon death. A lot of people assume that when one spouse passes, then just everything goes to the other spouse automatically. And that's not always the case. So I want to address how assets pass based on classification. So how assets pass depends on how they were owned. The asset could be owned individually, just your name on the account. It could be owned joint with right of survivorship, and you've got both spouses, and then it passes to the surviving spouse once that's been activated with the bank. There are beneficiary designations out there, POD, TOD, I won't get into that. It could pass through a business entity, or it could be owned by a trust. So we'll start by talking about assets owned by an individual. When an individual owns an asset and they pass away, their assets become the estate of the decedent. The estate is kind of like an entity that comprises all of the assets, the claims, the receivables, everything of value that the person had. Now, when somebody passes away, their estate does not automatically pass to the surviving spouse. In pretty much every state that I'm aware of, and certainly in Texas, we have freedom of contract to decide how our possessions are going to be distributed. And while most people are going to want things to go to their spouse, it doesn't automatically happen. So if the assets are held by the estate, how do we get authority to transfer the assets? Well, in order to transfer an asset, transfer a bank account, transfer title to a home, you have to have signature authority to do so. And so probate is the court process where a judge signs an order that authorizes the transfer of the assets. And there are a number of different types of probate here in Texas. So we'll start where there's a will. So if there's a will, the will doesn't do anything until it goes through probate. It's a set of instructions, but it doesn't have authority until a hearing is held and a judge signs an order that says the terms of the will are valid and can be carried out. And so if we have to do a full probate, that's where we have the executor in the will appointed and granted authority to administer the estate. And their job is to marshal the assets, collect everything that has value, and they need to field any claims against the estate, reimburse people that have paid for last expenses, for example, pay administrative costs, and pay outstanding debts, depending on whether they are properly presented as claims. A less involved version of probate that is appropriate in circumstances where one spouse passes and all we're trying to do is get the house transferred to the surviving spouse's name is probate as a muniment of title. Now, muniment of title is just a fancy way to say the will speaks for itself. We don't have to have an executor appointed, but the will is valid and it says what happens to the house. One of the biggest misconceptions I encounter when people call me when somebody passes away is they think when the spouse passes, both spouses have their names on the deed to the house, and so it just automatically goes to the other, right? That's not true. You have to use probate in order to get it consolidated under the surviving spouse's name.
Austin, can I jump in there for a second?
Certainly.
One thing that on exactly what Austin was just talking about, it's very common, happens all the time, that when that first spouse dies, the taxing authority, CAD, gets hold of that information. And so they take the deceased spouse off of the tax bill. And then that's the only piece of paper you get that tells you anything about your home after you've moved in and bought the house until you get a release of lien. And so a lot of people will take that to mean that the house is now only in their name. But the truth is that is just a bill. It has nothing to do with transferring title. And we've had a number of double probates when the kids come in and the second spouse has died, who find out that they should have done probate with when dad died, and now that we've got to do dad's probate and mom's probate. So be aware of that. It's a good thing for people to know when they've lost their spouse that it is not automatic, and don't rely on the tax bill.
Yeah, absolutely. If the spouse passes away and they did not have a will, there are different procedures, and the outcome is likely different. When you pass away without a will, the law will have essentially a will written for you, where the members of Congress have gotten together and said, okay, based on this circumstance, this is who should get the assets. And that's typically not what you would have wanted. There are a lot of circumstances where the surviving spouse does not receive assets and it goes to kids instead. In a blended family situation here in Texas, if a spouse passes away and they have children from outside that marriage, their share of assets, generally speaking, is passing to their children and not to the surviving spouse. And that can be devastating news to a surviving spouse who just assumed that everything would go to them when first spouse passes away. So under Texas law and the law of every other state, there's a formula for who receives assets based on circumstances. But that formula is not applied automatically. There are a number of ways through probate that we get it applied. So the first option would be using an affidavit of heirship. Now, this is only appropriate for transferring real estate to the heirs of the estate. So the primary residence, if that's all that has to be transferred, this is an option, though I personally don't think it's a good option in most circumstances. It's something that can be done quickly, where the documents are signed, witnesses testify that with their signatures, they sign affidavits to say that this is the family circumstance and this is who should inherit, and that gets filed in the deed records. There are some downsides to using that. There's a difference between what is legally required and what a title company will insure title on. And so that can create hurdles in trying to sell the property later on. And under Texas law, an affidavit of heirship can be challenged for 5 years after it's filed. So it's not really solidified for 5 years. So it is the least involved and lowest cost option, but it's not the best option in a lot of circumstances. So your next option would be to use a small estate affidavit. Now, Texas law has a provision that contemplates a scenario where the first spouse passes away, the surviving spouse needs to get assets transferred, but there's not a lot of complicated assets that need to be transferred. It's pretty straightforward, and so a less involved version of probate is necessary. This is appropriate when the value of the estate, excluding the value of the homestead property, everything else is worth less than $75,000. The homestead property can only be transferred using a small estate affidavit if the home would pass to the surviving spouse or to the minor children that live in the home. It's the only circumstance this works. And that gets filed with a court, and a judge signs an order, typically within about 2 weeks. And then that order can be presented to the financial institutions to pay out the funds to the named heirs. Next option is a full judicial determination of heirship. Now, this is a probate process where we file an application and we say, based on Texas law, these are the people that should inherit from this person. The court takes that application and they appoint another attorney. And that other attorney's job is to meet with family members, friends of the family that wouldn't inherit and therefore would not be biased, and ascertain if the facts in the application are correct. And then there's a hearing where evidence is presented. Those credible witnesses testify to say who the legal heirs are. And then if everything lines up, then after the hearing is held, the judge signs the order that says these are who the heirs are of the estate. Now let's talk about the probate process. So in probate, we're trying to transfer the estate. And that's generally speaking your stuff, the things that you own. If you have a will, that will dictate how things are to be done, the way that you want them done, but it does have to go through probate. If you don't have a will at all, then the process is applied based on what Texas law says. But in going through that probate process, it doesn't immediately go to the beneficiaries or heirs or the distributees. There are a lot of fees in that process. So the executor is entitled to reasonable compensation. There are attorney's fees going through that process. Accounting fees could be necessary. The courts have their costs. When you pass away and don't have a will, you've got another attorney involved, and that attorney ad litem keeps track of their own time and charges that against the estate. You could have to do appraisals. There could be a need to get a bond to guarantee performance. And after all those expenses are paid, then things can get to the heirs. And there's some problems with that. The probate, depending on the circumstance, for one probate could be $5,000 to $10,000 in most areas. It can take 6 to 8 months for a court date. So we'll get clients that say, okay, we need to sell the house, or we need to have authority to assign to repair a major issue with the house. We'd have to do probate. Well, I file a probate and it's a hurry up and wait. There's a county here in the Dallas Metroplex that you will not get before a judge for at least 6 months, but it's more like 8 in most circumstances. And so that can put your loved ones in a bind trying to take care of your affairs, but they're not able to do that because they're waiting on the court. There is after the court hearing is done, we can send out notices to the creditors so they can present their claims and we can determine if they're valid or not. And we can even bar some claims if they're not presented correctly. That process by statute is 4 months after the probate hearing has taken place. With a probate that's filed with the court records are open and available. Anybody that wants to see what was in your estate can call the court and get a copy of your file. There's open access. And probates are easier to contest. So if the first spouse passes away, had their own children from outside the relationship, and the will gets filed for probate, or we're having to determine heirship through probate, then those children are notified and given the opportunity to file into that case and say, well, it should be done differently, and that can create heartache. The next way you can own an asset is through joint right of survivorship. And that's very popular with financial accounts. So a husband and wife have a checking account at the bank, both of them are listed on it. Most of the time it's going to be set up with right of survivorship. So the first spouse passes away, you present the death certificate to the financial institution, and then they'll take the deceased spouse's name off and everything will be in the surviving spouse's name. But I want to caution you, not all joint accounts have right of survivorship. It's rare, but sometimes we encounter joint accounts that were set up to not have right of survivorship. And so there are hurdles of trying to get that account closed out and move to a different account. Now, the right of survivorship does not go through probate. It happens by contract. There's a downside is that you're only planning for the first spouse to pass away. When the second spouse passes away, it doesn't pass to anybody if it's set up during the right of survivorship. And so if you have your account set up that way and you both pass, then those assets are going to have to go through probate. Next, we'll talk about beneficiary designations. With financial accounts, you can name beneficiary designations to pay out upon your death, and that avoids probate. But I want to caution you again, what happens if the circumstances have changed? If you have named your kids as beneficiaries and say one child has passed away, but you haven't updated your beneficiary designations, that can be very problematic, and it could make things pass differently than how you wanted them to pass. And it could force us to go through probate for that child's estate. This is a very poor option for minors and incapacitated beneficiaries. Because if you name them as a beneficiary, the court has to be involved in order to gain access. So if you say, well, I want my 15-year-old grandchild to be the beneficiary of my life insurance. Okay, well, in order to access those funds while they're under 18, we have to go file for a guardianship with the court to have authority to manage those finances. And that would be paid out of the life insurance proceeds, but then you're reducing the amount that would go to that grandchild, whereas there are better ways to handle that. We'll get to that in a minute. Next, you can pass through business entities. If you own a business entity yourself, that could require things to go through probate. If you have gone through an attorney that does a good business entity for you, there could be some inherent succession planning in the documents itself. If you just go to the Secretary of State and register an LLC, you've reserved a name, but you don't have any succession planning or really anything to back up your entity. So the terms of the agreement for the entity will control, and sometimes they'll include what we call buy-sell provision. And so if you structure this properly, you could have it set out so if you've got business partners, they could be made whole, buy out your interest. They could pay for it themselves. They could use life insurance on your life to do that. There are ways to plan for that succession so that we don't have to get stuck going through a probate process. The next way you can own assets when you pass is through a revocable living trust. And this is a great option to pass assets in the event you pass away and you want to avoid probate court. This is going to be your best option. Your trustee, the person who is like an executor, they have managerial control based on the agreement that you put together. They have immediate control after you've passed away. So if first spouse passes, surviving spouse can immediately take control of the assets and do what they need to do with those assets. So I like to use an analogy. A trust is kind of like a warehouse. You store your assets inside of this warehouse. You have keys to get in. In the event the first spouse passes away, the other spouse still has a key. They can access those assets, do whatever they need to do with those assets. There's no court involvement in the event of incapacitation or death. And after you both have passed away, you can say who you want to get keys at that point without having to go to the court to get new keys moved. And inside that warehouse, there are detailed instructions for how you want everything done. You determine who your estate goes to, how it goes to them, and the timing for that to happen. So a lot of people ask me, okay, what's the difference between using a trust and using a will? Well, with a will, you have to go through probate. It doesn't do anything until probate has happened, and that involves costs. With a trust, probate is not necessary. With a will, you're looking at delays. The fastest county around, I can get through a probate in 6 months, and that is blazing speed, going as fast as we possibly can. We have some probate cases that, depending on the circumstances, that it's a year or two in, and we're still trying to get those wrapped up. With a trust, your trustee has immediate access. There's no delay in getting access to the funds. Privacy. A will is public. It is filed with the court and everybody has access. With a trust, you've got complete privacy. Nobody has to know. None of your snooping neighbors need to know what assets you own. With guardian of children, with a will, it covers guardian of person, but not always guardian of the finances. With a trust, you've got complete protection. So that example of the life insurance going to the 15-year-old, if you pass it through a trust, then you can have terms for how you want the money managed. And say, well, I want them to have their college paid for, or healthcare costs paid for. You want it managed until they're a little bit older. So an 18-year-old is technically an adult in Texas, but I haven't met very many 18-year-olds that are good with managing money or make sound decisions in general. Their brains aren't fully developed until 25 or 26. And so with a trust, you can say you want it managed for them by an older, wiser adult, and then you can turn it over whenever you think they'll be able to. And if you become incapacitated, a will it requires a court-directed process, whereas a trust, you've got full protection. The trust covers how everything is done, and it doesn't have to go through the court. So those are the ways that assets can pass. And Susan presented the practical steps to take in the wake of losing a loved one. Thank you for tuning in. It's a pleasure presenting to you all. If you have any specific questions, we can do Q&A now. I haven't been watching the chat, but I'm sure there's a few questions in there.
Sheila, are you going to cover the Q&A or you want us to do it?
You're on mute. You're
Yes.
still muted. There you go.
Okay.
Okay.
All right. We have many questions here. Yes. And I've tried to get them in the order that I got them or that I saw them. Okay. They're coming either from the Q&A or the chat. The first one is coming from the chat. I mean, the Q&A. Karen asked, should you create a trust to protect the transfer of residence to spouse?
Absolutely. The transfer of the primary residence can happen automatically without any paperwork or anything. Your trust will provide that the surviving spouse has that for their benefit. And you can be very detailed with how you want that done. So, for example, in a blended family situation, you may want to make sure that your spouse can live in that home, even if it was your home before you got married. It's your separate property. You can make sure that your spouse can live there and prevent your children from stepping in and trying to take that right away from them.
Okay. Matthew asks, who do you call first when someone passes?
Matthew, I would say, I mean, obviously there's some things that have to be done around the death, like contacting the funeral home. But as far as the professionals go, call your attorney first. Oftentimes when I get those calls, especially if it's a living trust situation that they've set up, my first words to them are you okay? You need to take the time. There's nothing urgent. But if there is something that the spouse thinks is urgent, they can run it by the attorney and either get peace of mind or get some action on it. So calling the attorney first is, or earliest on, is really critical.
Okay. Melissa asks, does the family receive confirmation from the funeral home that Social Security was notified?
I believe that the funeral homes have to do it. They're required to do it. I have not actually sat in those shoes to know what kind of confirmation you get. But my experience in just the family members that have died, that's how the banks end up finding out a lot of times that someone has passed, because Social Security then notifies them. And so I don't know about a confirmation, but I do know that it's a requirement of the funeral homes and the memorial services, different professionals you work with in that arena.
Okay. Jenny asked, how is the surviving spouse's income calculated? Because Susan had mentioned that it can change. Does the living spouse get half of deceased spouse's Social Security if theirs is less?
I don't know the formula. Austin, do you know the formula?
I don't. I think it depends on the number of years worked and the amount you've contributed in. But I don't know the exact details of how that's calculated. We may have to reach out to Social Security to find that out.
Okay, Matthew says, what do you mean handle debts appropriately? Is anyone else responsible for the debts of the deceased?
Oh, that's a great question.
That's a good question.
So nobody, the estate is responsible for those debts. And so an example, first spouse to pass away, if they had a credit card that was only in their name and they ran up a bill, the surviving spouse is not obligated to pay for that. The kids aren't obligated to pay for that. That's something that is processed out of the estate. And if we're going through the probate process, We would send what we call a permissive notice to the credit card company. It's permissive, it's not required by law, but we do it because if you do, you can initiate a sequence where they have to file a proper claim within 120 days of receiving that notice. And a proper claim has to be either filed into the case, sent to the attorney or the executor by certified mail, or hand delivered to the attorney or the executor. That step right there trips up a lot of debt collectors. Because a lot of debt collectors are nationwide, they're not specific to each state. And so they'll just send a bill and say, okay, this needs to be paid. And if they don't abide by Texas law says that bill is barred. If they get to the 120-day mark and they haven't presented it properly, the estate is not responsible for paying that debt anymore. So that is a process that's important to review after somebody passes away. It's important to figure out what debts they have. Now, inherently, there can be some difficulty figuring out what debts are out there. The credit reporting agencies will release a credit report for a deceased person. They'll release that to the surviving spouse, or they'll release it to the executor or administrator of the estate. And so that can be a helpful tool to figure out what debts are out there.
Okay, Melissa asked, who can request a death certificate? Anyone?
Not anyone. It has to be an immediate family member. So that's typically surviving spouse or children.
Okay. Cheryl asked, if we donate our body, this is a good question. If we donate our body to UT Health Science Center, will we get a death certificate from them?
I believe what happens there is they report the death. The death certificate doesn't come from, it comes from the state of Texas. It'll come from the county where the death occurred. And so there will be a death certificate issued even when you do that. So, but it's not coming from UT Health Service Center. It would be coming from the county, and it's a state document.
Okay, Mindy asked, if there is a will, can you do an affidavit of heirship without going through probate?
It's possible. It's tricky. So you can do an affidavit of heirship and say there is a will, the will is attached. That can create problems for title companies. And they may say, oh, there's a will, then it has to be probated. It has to go through the court. It can be even trickier if the provisions of the will are more complicated than just outright distributions to a surviving spouse or adult beneficiaries. So if it calls for different percentages or have assets managed for beneficiaries, then an affidavit of heirship is definitely not appropriate.
And it's not a way around the terms of the will. If it's a blended family and the will leaves everything to the surviving spouse, but maybe the surviving spouse is not in any shape to actually make things happen, and the kids want to step in and say, oh no, we want our share. It's not a way around the terms of a will.
Okay, the next question is Matthew. Are these normal probate times that you're giving or extremes? I thought a Texas probate could be accomplished in Dallas in about 2 weeks.
That couldn't be further from the truth. So Dallas is the bad county for probate around here. You cannot get through probate for an estate in under 6 months. You're not going to get a hearing. Now, a small estate affidavit doesn't require a hearing, so those can be approved on a quicker time frame. But probating the will or judicial determination of heirship, I can guarantee you that's not happening for at least 6 months after it's been filed.
And even in the counties that weren't hit so hard by COVID and are running on time, it's still at best going to be a month or two before you get the hearing date, because there's processes that have to be gone through, and then you've got to get on the court schedule. So every county is different in that way, but I don't know any place where 2 weeks is what would happen.
No.
It has to be filed for 10 days before you can even ask for a hearing. So,
Okay. Debbie asked, if there is a will but zero assets except a checking account and some outstanding debts, do you have to go to probate?
Well, it depends on how the checking account is owned. If the checking account is held by one person's name and they have died, then we would have to use the will in order to gain access to that checking account. That would have to go through probate. If there was right of survivorship or a beneficiary designation, then those will pass by contract, and the will, not only does it not need to be used, but the will doesn't even apply. I don't think I mentioned this through the presentation, but if you've got beneficiary designations, those pass by those contracts. Your will does not override those terms. So if you've got one beneficiary listed because you think it'll just be easier if it goes to that one child and then they can take care of the rest, then that one child legally owns the contents of that account, and the will does not split it among other children. And then if we're going through probate and there are debts, then we would want to resolve those and hopefully get some of those eliminated. Now, if the only asset is the checking account and it passes by right of survivorship or beneficiary designation, then we wouldn't use the will. The will is used to transfer assets, and if everything transfers outside that process, then we wouldn't use it.
and nothing requires a probate if all you've got are debts. Leave it to the creditors. They have an avenue themselves. If they want to file for a probate, they can. I've not seen it done often. Almost never. Especially when they realize there's just not any assets to go after.
Okay, good. Sheila asks, can you get a payout from a life insurance policy before probate is settled, or will those funds be included in probate?
Well, it depends. If there's a beneficiary designation and that beneficiary is alive, they have their capacity, they're an adult, then that will pass outside of probate. But if there are any issues like a minor beneficiary or a beneficiary with special needs like autism or Down syndrome, then that could force things to go through the court.
Okay. Sharon asks, will you cover the living trust procedure?
Well, with a trust, you establish it while you're alive, and you align your assets with it while you're alive. And that's a whole lot easier for you to do with your assets than it is for your loved ones to try and figure out after you've passed. And so after you've passed, that's when trust administration starts, and that's Susan's realm. So Susan, I'll let you take it from there.
Yeah, and really it just depends on how you set up your trust, and that there's a lot that goes into that. That's a whole other subject of just details that we get when we determine what kind of trust it's going to be. But the reality is, if you've done what Austin mentioned, you've aligned your assets with the trust, some people call that funding your trust, then the trust owns it, and that doesn't change because somebody died. And so then it's just a matter of looking at how the trust was set up and what needs to happen at that point. What the it's a contract, and whatever the instructions are in the trust, that's what's going to happen moving forward.
Okay. Myrna has a question. Is it expensive to change a will to a living trust?
We're going to tread lightly here. We are not here to sell services. We're here to talk about the subject and educate you on this. Pricing depends on the law firm you go with and what options you choose. Not every trust is made the same. There's not one trust document promulgated by the State Bar of Texas. There are very simple trusts. There are some trusts that are too simple and don't go into enough detail for what you want done. And there are very complicated trusts that provide a number of features that may be necessary for your estate, especially when there's blended families or estate taxes we need to plan for, or children with special needs. So the cost to do that, it depends on your circumstance, but pretty much every trust option I've seen attorneys offer is cheaper than paying for 2 wills for a married couple and then doing probates for both spouses after they pass away.
And to add a little bit to that, I saw a question pop up and I'm just going to jump out of order because it's so critical that you guys all hear this. Having a will does not mean no probate. In fact, the only way the will can be followed is if you put it through probate. Having a trust, if it's properly funded and all is done correctly, is where you will avoid probate. And like Austin said, those things vary. I mean, the prices and all of that varies. And it's not just to be picky about the wording. You're not actually changing your will. It's a whole redo. Because you have a totally different kind of will that goes with a living trust. And so it's one of those things that it just really depends on the circumstances and who you've got doing it for you, as far as the expenses go. You want to make sure you're dealing with somebody that knows how to deal with trusts.
Melissa asked, is probate in the county where the decedent lived, or do you have options?
So it depends on a number of different things, but typically it is in the county where the person lived at a fixed place of residence at the time they pass away. You can get into some gray areas of, well, did they actually live in that home anymore? Were they in an assisted living arrangement for years and that was really where they lived? Or there are some courts that will allow you to probate in different counties by agreement. If all the parties agree, we can just have it here. And these are all Texas rules. I don't know, I can't speak to all 50 states. And there are even circumstances where if somebody died in another state and they have a bank account for a national bank that has a presence here in Texas, next of kin can file a probate here in Texas to gain access to that. So it really depends on the facts, but most often it's where the person lived at the time they passed away.
Okay, Suzanne asked, when a spouse dies and the living spouse refuses to pay for their funeral costs and deceased spouse appointed his children to be in charge, but they do not have access to the funds since the DPOA is no longer in effect after death, who is responsible and how can it get paid from the deceased spouse's funds? Boy, that's a good one.
That's a tough one.
Yeah, that's a fantastic question. Terrible
Go ahead.
circumstance, but a fantastic question for this presentation. The deceased person's estate is responsible for those funeral and burial costs. Texas law has an order of priority for who gets paid first, and that's at the top. Up to $15,000 can be claimed before anything else gets paid out. But you have to have a probate open to get that. So in the interim, you've got to figure out who's going to take on the financial obligation, because when somebody passes away and you're trying to take care of the last arrangements, probate hasn't happened yet. Nobody has access when you're using a will or you have nothing at all. And that's another circumstance where, again, I like to recommend using a trust because there's instant access, and that will stipulate that those fees need to be paid out of the trust by the trustee. And if they don't, that's a breach of their fiduciary duty. And that can get them removed if they don't pay for it.
Okay. Next, Karen says, if a spouse is incapacitated, or no, I take that back. I'm doing this out of order. I'm sorry. Vicky asked, what about an adult child who has special needs?
Great question. I've got an entire hour-long presentation. We could talk about just that. But real quick, when you have an adult child with special needs, in the event you pass away and you leave assets to them, they may not be able to manage those assets. And so you want to have a trust in place to have somebody else manage those funds for them. And if you go to a good attorney that does this kind of work regularly, you can have provisions in that trust where the trustee is explicitly instructed to pay for things to supplement the lifestyle of that special needs individual, to make sure they're able to participate in social functions and sports and family events and attend religious ceremonies. There's a lot of detail you can go into with making sure your special needs child is cared for. The other important thing to think about is if your child is receiving needs-based benefits like Social Security or Medicaid, if you leave them an inheritance, they are disqualified and they have to spend down your inheritance that you've left them before they can get back on those programs. And that can create a scary gap in time between exhausting the funds and getting reapproved to be back on those benefits, especially if the child's not able to work and provide for themselves. So there's a special type of trust, both special needs trust or supplemental needs trust, and it's designed so that you can leave an inheritance that benefits your child and supplements their lifestyle, makes it better, but it does not disqualify them from receiving those government benefits. So it is critical, if you have a special needs child, you have to talk to a trusted attorney to make sure there aren't problems after you pass.
And just to clarify, those government benefits are not always just financial benefits. A lot of times they are health care type benefits, but you qualify for them by having the right financial setting. And if it can be a matter of life or death if someone gets knocked off of those governmental benefits at the wrong time. So it does make a difference, a huge difference.
All right, next question. Can you pass a primary residence through a deed?
Good question. There are, well, in Texas, there are ways you can do that, but it doesn't happen automatically. If a married couple buys a house together, it does not automatically go to the surviving spouse. There are two options for a type of deed that can make that happen. There is a transfer on death deed, and that's explicitly authorized by Texas statute. And there's what we call a ladybird deed, and that is a deed that is backed by common law. And so there are very subtle distinctions between those two, but they can be used to transfer the primary residence to your intended beneficiary without probate. Now, that only applies to the house. And I've had some very messy probates arise because people tried to use those types of deeds and they didn't work. They did something different than what they thought they were doing, or there were still other assets that needed to be handled. And it hurt somebody's feelings that one person got the house and now they're fighting tooth and nail in court over whatever's left. So they can be useful in certain circumstances. Especially with Medicaid benefit planning. If you're trying to be on Medicaid and you want to avoid Medicaid estate recovery after you pass away, a ladybird deed can be a very helpful tool there. But if we're not worried about Medicaid planning, a trust is going to be a better option than just trying to use one of those deeds.
Next question, Bonnie asked, do airline advantage mileage perks pass to the spouse?
I don't know the answer to that question. Do you, Austin?
I've not had to do that, but I have to believe that's something that's governed by contract.
Yeah, that would be my guess
Contract with
too.
the airline would have to say what happens.
Yeah, the terms in the fine print.
Okay, for a final income tax return, is this filed at the time of death or with the normal tax year filing?
You would file that by April 15th or with an extension October 15th of the year following death. So it's not due right away. It would be a normal tax return. It's just, if any of you have ever done your own taxes, like through a program or something, you'll know there's a question there. Is this spouse deceased? And so your CPA answers those questions appropriately so that it gives the IRS the right information.
Okay, Amy asked, what happens if you only have a copy of the will and not the actual signed original? Is the copy adequate?
It can be, as long as there's no evidence that it was revoked. And so there's some hoops you have to jump through to make a copy of a will work, but it can work.
And you have to get the intestate heirs, the people that would inherit if there were no will, to agree to using the copy of the will. And that can be very problematic if your intent with a will is different from what the law says should happen with your assets. So an original will is critical to have.
Okay. Karen asked, if a spouse is incapacitated already, can you still create a trust?
Another good question. It depends.
You know that half these answers are it depends.
Well, of course.
We're attorneys. Everything we say starts with it depends. It depends on the incapacitation, level of incapacitation. If I have a married couple come in and say, okay, this spouse was just diagnosed with Alzheimer's, they're showing early stages, mild symptoms, then most of the time they still have the ability to sign a trust. The requirement to sign a trust is the same as signing any contract. Generally speaking, you just have to understand what's going on. With a will, you have to understand that you're making a will. You have to understand who you would be leaving assets to, and you would have to understand the assets that you are passing with that will. So early incapacitation, trust is a great option because there's provisions in there to help manage estate assets while they're still alive. You may not necessarily need that spouse's signature on finances, and that's a great tool to avoid legal guardianship. If they are incapacitated and it's moderate to severe, we may reach a point where they're not able to sign those documents legally, and we would have to look to see if they have any existing documents. Because if they did a power of attorney that specifically authorizes the power of attorney to sign a trust on their behalf, then we could do a new trust where the power of attorney signs for them. So it's very fact dependent on the severity of the incapacitation, their ability to understand what's going on.
Samantha asked, is there a minimal estate value for setting up a trust?
No.
Not at all.
No.
I mean, if you own a home, then the house is usually what triggers probate. And if you have a house and a checking account, it is better to go ahead and get a trust set up. One of the things we didn't really touch on, Austin did just a little bit, but even with a joint with right of survivorship, if we've got a surviving spouse or maybe the couple's in a car accident and the survivor is incapacitated, having a joint account, we don't have anybody that can then act on their behalf, and that's going to require a guardianship. And so by having everything in a trust, even if there's incapacity, the next trustee can step in and take over things. And so that could happen at any level. And there's different levels of trust for that very reason. It could be very, very basic and avoid probate and guardianship.
And I've set up multiple trusts for people that literally just exited bankruptcy. There's a misconception with trust that it's only for the rich and famous. Mark Cuban needs a trust, but not the average person. The average person benefits from having a trust set up, and it's far more common to have a trust than most people realize. Here in Texas, you can look up real property records, and if you look at any state, any neighborhood in the county, and we just run a search for the street, we're going to see a couple of trusts that own houses. It's very common.
Okay. If the house is only in the spouse's name, could that spouse's siblings or nephews and nieces have something to do with this?
If it is only in the deceased spouse's name, the first spouse, their name is not on it. It does not necessarily mean under Texas law that is just the deceased spouse's asset, though it could be. So if they owned the house prior to getting married, that is separate property. And under Texas law, separate property can pass to other beneficiaries than just your spouse. Now, if it was bought while they were married and for whatever reason it only has one spouse's name on the deed, under Texas law, the other spouse has a 50% community property interest in the property. So it really depends on the exact facts of what's going on. So it might go to other people, it might go to surviving spouse if there's not any kind of will or trust in place. But that's a great circumstance for just go ahead and do the estate planning if they're still alive and avoid any questions. You make sure your house goes to who you want it to go to.
And on top of that, Texas has a law protecting that surviving spouse. Even if the house was the separate property of the deceased spouse, and this actually happened in my family. My aunt got married and moved in with her husband in his home that he owned before marriage. He died first. There's a statutory right to be able to remain in your homestead. And so for the surviving spouse. Now, you have to be able to maintain it. Sometimes it's not practical, but they have a life estate. The surviving spouse has a life estate in the home they lived in, even if it was in no way their property. And so that is just to protect surviving spouses. It was an amazing thing for my aunt because until she died, she lived in that home. And his will left everything to his brother, but his brother couldn't touch the home, do anything with it until she passed away.
All right. Gail says, just to confirm, if both spouses' names are on the house and one passes and there is a will in place, the home has to go through probate for the surviving spouse to retain ownership.
Yes.
Yes, to get the other half of the ownership, not retain. They keep their own half, but to get the other half into their name, they have to probate the will.
Okay. Now, okay, what happens, this is in the same genre, what happens with the spouse when they live together for many years, but they're not legally married?
That creates issues in probate. The issue that can arise is maybe they weren't formally married, but were they common law married? In Texas, common law marriage can be established based on a couple of different factors. And I see this thrown around a lot. There's a lot of bad information out there. This is what you need to establish common law marriage. It has to be an agreement between the partners that they are going to be married. They have to cohabitate together, and they have to represent to others that they are married. And so when you have a circumstance where there's not a formal marriage, but there is a romantic relationship between the parties, then that can create a circumstance where that other partner claims that they are the spouse, and they may not have necessarily been the spouse. It could have been an understanding by the spouse that passed away that they're not going to get married and that assets pass differently, and that can create major conflicts in the court later. There are ways to define what that relationship looks like. There's something we call a cohabitation agreement, where if you're not married, you can still stipulate what the rights are of the parties that are living in that home. But again, a good will or good trust is going to avoid a lot of the conflict that can arise under that circumstance.
This next one is from Anonymous. This is a great question. You know that the deceased had insurance policies, but you don't know the name of the insurance companies. How do you find that out?
I was hoping Austin was going to jump in on this one. There's not an easy way to do it. It's my understanding that there is some sort of a list at a government level, but that it's not reliable. And so without something getting you started, it's very, very difficult to locate the insurance policies. Now, I will tell you, as we're all aware, insurance companies will have changed hands over and over. And so I've got clients right now that are working on very, very old policies, and they're still in effect, but he's got to trace out to where those policies are owned by whom now and reach out to the right insurance company. Somebody did pop up there and say the unclaimed funds of Texas, that's a great place to go, but it takes years before it hits that list. And so it's not something that you'll know about. The insurance company will hold it for 2 or 3 years. And after they find out the person has died, and so that's the first thing, is they may not ever even find out that the person has passed. And so the chances of it making it to unclaimed property in any kind of a reasonable time frame is really small. So it's just not an easy thing to do.
Okay. If the spouse is incapacitated, can you amend their will, or is that only with the trust?
If a spouse is incapacitated and they don't have legal capacity to sign the will, then there's not a provision for where like a power of attorney could sign a new will for them. Trusts can be authorized by power of attorney, but not wills.
And there are other ways too that trust can be amended depending on how the trust is set up. But yeah, wills, you can't do a codicil to a will unless the person can sign it themselves.
If the surviving spouse has Alzheimer's and the two together have a house, bills, and accounts in both of their names, any suggestions for easier transfer of assets to the kids to help care for the surviving spouse? The will lists an adult child as an executor and first on their POAs.
Okay, I would want to see that power of attorney and see what it authorizes. In an ideal circumstance, that power of attorney would be authorized to create a trust for the benefit of the surviving spouse with Alzheimer's. And if the assets are aligned with the trust, then that's a powerful tool for incapacity and death for the easy transition. If the power of attorney does not authorize that kind of transaction, then you are really limited to trying to use that power of attorney while they're alive. And then after they pass away, you use the will and you go through the probate process. It's better than having nothing. Having a will is, I would say, the bare minimum that people should do, but it's way better than if they've got nothing at all. So I don't want to paint a picture that it's just absolutely devastating if somebody has to go through probate. You can go through probate with a will. If it's a good will, it's typically not too bad, but there are downsides that a trust is designed to avoid.
Something else to think about in that scenario is looking at the will itself of the deceased spouse, because it might have some sort of a contingent trust or suggest a way to set up a trust within the will if you probate the will. And so there may be that authority within the will to do that, and might, and I say might, be a reason to probate in and of itself. But that's why we aren't fond of testamentary trusts, because if a trust is coming out of a will, the will has to be probated to create the trust. And then at that point, you're gone and funding it becomes difficult. So, but that's another thing I'd want to look at is the terms of the will.
Okay, if you have both a will and a trust, could that create a conflict? Which one supersedes the other?
There's not a conflict when you do those together. When we prepare a trust, we always prepare a will to go with that trust. But it's a different kind of will. It's called a pour-over will. And it's designed as a backup mechanism. When I go through documents with clients, I tell them, we hope we never have to use this will. The plan is to not use this will. But if there is an asset that slipped through the cracks the bank didn't do the change of ownership correctly, or years went by and the person with the will and trust opened a new account and just forgot to tell them they've got a trust, then a will can function as a backup mechanism to transfer those assets to the trust. And in some circumstances, we're able to use a less involved version of probate in order to activate that provision.
If someone is already on Medicaid, can they still draw up a ladybird deed to avoid the estate going to Medicaid recapture upon death?
Yes. Yes, you can. And I highly recommend it.
Okay. Let's see. Can you add assets to a trust once it has been established?
Absolutely.
Mhm. Yeah, a trust is designed acknowledging that you're going to change the assets that you own between now and the time you pass away. When you set up a trust, I don't go into the body of the trust document and say, these are the following assets that this person owns, and this is where they go to. It speaks more big picture, and it's designed so that if you open a new account, close out an account, have different assets, if you have those owned by the trust, the terms of the trust apply to the assets, but that ownership is changed outside the trust. It's done at the bank or at the title company.
Okay. If one spouse is incapacitated and the other spouse is the POA, can they change from a will to a trust?
It depends on what the POA says. If the POA authorizes trusts to be created, then yes, they could do that.
Okay, let's see.
Had a lot of good questions.
Yeah, it's been great. And so many of you have hung with us still. Thank you.
Yeah, thank you. Thank you all so much for sticking with it. There has been a lot of questions. This is Stump the Presenter, right?
And they've done it a couple of times.
Yeah. But it depends.
Yeah,
It always works,
it
right?
depends.
So, Sheila, if you we're right
Yes.
at 11:30. Let's at least go over the CEUs one more time, because
Absolutely.
Sheila has to tell you that it depends whether you get CEUs or not when you do this stuff. So you go right ahead, Sheila.
And also, I have to say this, and if any of you are on here that this happened to, I've had 3 or 4 in the last month try to send me something from a year ago, and our guarantor will not go for that. It needs to be the sign-in sheet and the eval form need to be sent to us in a timely manner. We're happy to issue these certificates, but they really need to be sent in a timely manner. I understand that things can fall between the cracks, but a year is not, that's not, I'm sorry, but we can't do that.
Going forward, let's give them a deadline. Let's give them a deadline of when it's got to be done by, because then, timely manner could be something different to everybody. But
Yes.
on all the other ones, we've given them a 1-week deadline for them to get it in. And so we'll work on that.
Okay. All right. And by the way, some of you that are asking basic questions about living trust, we did that one last month. So I know Marty has those recorded.
Yes.
And it's on your YouTube channel, is that correct?
It is. It's up on the YouTube channel. We also have the one we did a while back on special needs trusts.
Okay.
That's on the YouTube channel. So on the bottom of all my emails is the link to our YouTube channel. You can even subscribe to it, and it'll notify you every time we put a new one up. But it goes back all the way through COVID.
So I would highly recommend that, because so many of this is a very, as you can see, very detailed part of the law, and it doesn't matter who you use, as long as they know what they're doing, they will tell you the same thing. It's very detailed. And so all of these questions, I was joking about them telling you it depends, but apparently it really does, because this or that or the other, and without seeing it, they can't really tell you that. So this is very detailed. So please take advantage of what Marty is giving you, all of these programs. And
when I send out the follow-up email, you'll see below my contact information, on the bottom of all my emails, you'll see there's a link to the YouTube channel.
okay. All right. But I will send Marty, which I have not done, my bad, the 2 forms to send you, the eval form and the sign-in sheet. That's all I need back from you. And then I promise you, I will very succinctly send you your certificates. Yes.
Great. And I guess we're going to wrap it up unless you have, is there more on there? Well, let me see.
There are. This goes on and on. So
But that's up to y'all. That's really up to y'all. But I forgot to add on the fact that when you close out of Zoom today, you should get a pop-up for a Google survey. Please fill that out. That helps us in reporting back on the goals and objectives we set forth when we applied for the funding for this. There'll also be a link to that in the follow-up email in case it doesn't pop up as you close out. But it's up to you guys if you want to keep going.
I think, Sheila, if I'm looking at it correctly, it looks like most of them are just thank yous, and I don't see any. There's lots of comments, but I don't see any questions.
Okay, I think they're asking for links to the YouTube channel.
Yeah, it's that kind of stuff.
So yes, so that's good. I know you'll send that out. So thank you very much. And next month we're going to do one on and this is funny, executor versus trustee. And this is funny because, well, it's not funny. I mean, it's not a funny topic, but it's interesting because I interviewed someone about a thing that we're going to do coming up, and she had this experience. She's on television, and she had a good friend of hers had a plane, a private plane, and he had a crash, unfortunately, and passed. And a couple of weeks later, he was 42. A couple of weeks later, she gets notified by an attorney that she has been named executor. She had no idea of any of this, and she doesn't know what to do. She didn't know. And so she had to reach out to these people and said, what does that mean? And the family's all calling her to try and do. So this happens a lot more than you think. So we felt that this might be a good idea, an executor versus a trustee, what the responsibilities are. And if you're named, which quite frankly, anytime you make someone an executor or a trustee, you should let them know this.
You should ask their permission.
Yes.
Yes, because she was a good friend and it was wonderful. I mean, lovely, but she had no clue of this. So, that's what we're going to try to, Rex is going to give this information next month about, and I think Susan, you may be helping him, but to give the idea about what is involved in each one of these roles, but to please let the person know if you
Make sure they're okay with it.
Yes.
They can't decline the
power of attorney or a medical power of attorney, especially those. Yeah. Yes.
Now, if you're making me a beneficiary, you don't have to ask.
And my name is spelled S-H-E-I.
Okay. Very good, y'all. Y'all, just an incredible presentation. Thank you all so much. This will be up on the YouTube channel within a week. We'll get that to you, and look for the follow-up email. Susan, Austin, Sheila, thank you so very much.
Thank you so much, Marty.
Thank you all. Thank you all for joining us, and you all have a wonderful day.
Thank you.
All right, you too.
Bye-bye.